You might think removing a director in the event of a dispute will be simple, particularly if you are the majority shareholder. In reality, it is rarely that straightforward. Founder, director disputes can move quickly from serious commercial disagreement to a serious legal risk issue, especially if a founder or a shareholder is a director, employee, and shareholder. The first step is to check the company's articles of association and any shareholders agreement. The articles may contain specific removal provisions, allowing the board to remove a director, deem resignation events, or compulsory transfer provisions. It is important to note that the model articles do not give the board a general right simply to terminate a director's appointment because relationships have broken down. If bespoke provisions exist, the process must be followed precisely, and it's unlikely to be as immediate as founders often assume. That usually starts with the mechanics. Can the board call a board meeting to deal with the issue? Has proper notice been given under the articles? Is the meeting quorate? Can the director concerned attend or vote? And can the decision be taken by written resolution, or do the articles require a meeting? These procedural points can all be critical. If the articles do not provide a suitable route, the company may need to rely on the Companies Act. A director can be removed by ordinary resolution of the shareholders, but the statutory procedure must be followed carefully. That includes giving special notice of the proposed resolution, usually 28 clear days before the general meeting, and it might surprise founders to know it gives the director the right to make written representations and be heard at the meeting. Importantly, statutory removal cannot be done by shareholder written resolution. However, removal from the board is only one part of the picture. The company must separately consider the individual's employment, share, option, bonus, and any contractual rights. If the director holds shares, the articles or shareholders agreement may include a good leaver or bad leaver provisions. A good leaver may receive fair market value, so how is that calculated? A bad leaver may be forced to transfer their shares at discount or nominal value. The company must also consider how any compulsory transfer, shareholder purchase, or company buyback will be funded and implemented. Employment law is also becoming more significant. At the moment, compensation for unfair dismissal is capped at about $120,000 or 1 year's gross pay, the lower of. The cap often gives companies a directors and framework for negotiating an exit. From January 2027, that statutory cap is expected to be removed, which could materially increase exposure where the director is also an employee, particularly for high earners with salary, bonus, pension options, or long-term incentives. The qualifying service requirement is also expected to reduce to 6 months. That is why some companies are reviewing senior leadership teams now. If difficult director issues are already on the horizon, businesses may prefer to address them before the compensation landscape changes. In many founder disputes, the safest commercial route is often a negotiated exit, covering resignation, employment termination, and share arrangements. A careful strategy can reduce the risk of invalid removal, tribunal claims, shareholder disputes, and disruption to the business.